international law works to the extent that member nations in the system enforce it. So, in theory, you can have a legal system that regulates the cyber world and cyber communications. But all you need is one or two states to deviate. So the question that then comes is, how do you punish them? And in fact, it's already clear, as some of our panelists have pointed out, that the theory of deterrence starts weakening in the world of cyber. How do we punish those who actually deviate from it? So in theory, it is possible because we now regulate some aspects of international aggression. For example, war is outlawed, you can defend yourself. In theory, we can do it. The paradox is that in terms of the United Nations, it may very well be that it will be the Security Council which is actually in charge of international security and enforcement. It will be up to the 5 major powers to do it. The question, however, arises from the fact you have revisionist states, could range from Iran to North Korea, that actually do not agree with that kind of policy.
Thank you very much. Ira, should we hand this over to the UN Security Council to regulate and to be the judge ultimately of cyber incidents and cyber attacks?
Well, there's definitely challenges in addressing cyber operations and cyber attacks, and we see that the discussions going on in the UNGGE, we see those conclusions as guiding for our behavior in cyberspace, and we would also like to see those conclusions to be leading for other states in cyberspace. So we do not necessarily agree that there would be needed, a lot of new legal instruments would be needed, because international law, as the previous UNGGE reports have already stated, applies to behavior in cyberspace. So in that sense, I would not say that we need any new treaties or any new laws. We just need a clear understanding of how international law applies to cyberspace.
Thank you very much. I've heard many times around the International Committee of the Red Cross the fact that yes, definitely we can be governed by the similar guidelines as those that were devised in 1863. Julian, what is your view, and who should be in charge? How would this legal framework, or could this legal framework take shape?
Well, the first line of defense is always the state. And I suppose that that's the first step we should take at home. There the legislation can be built, and there are several areas. The first is awareness. The second is education. Yes, it delivers on mid to long term. You need to elaborate. And at the same time, the third point is to have a dedicated body who has to deal with the different aspects of the cyber defense. Then for sure, states can come with ideas, and we are part of multiple multilateral organisms, beginning with the European Union, which already has its rules and already advances in that area. I already quoted the security strategy, the global security strategy, and the revisions each year, including 2019, very interesting part to read. And in NATO as well, we have already a debate on how Article 5 works in terms of cyber defense, as we know how it will work in hybrid warfare. That is related to your presentation, that hybrid warfare is not really a new thing. Well, you're right, but the difference is that the instruments are evolve and develop in such a way that really the hybrid warfare looks completely different, as the cyber warfare has different rules of the game. So I suppose that these would be the steps, and it's not a supposition, actually it's what happens. Each member state has already developed this. The understanding is that the first line of defense is the state, and for the Article 5, it's also the state who can come and claim that at some point it is under an attack, a threat from the cyber part or hybrid part, because I don't want to leave you with your very French presentation of that we've heard.
Okay.
Thank you.
Velimir, what is your view? We've talked about the first layer of defense, and this would be the national state. So what would the second line of defense be, or do you have different views?
If we are talking specifically about a situation where defense was already tried or is already ongoing, meaning that we are currently perhaps even in a state of armed conflict, then the official position of the OSCE is, well, better luck next time. So, however, when it comes to the prevention of wartime activities, I would say that obviously you have the conclusion of the 2015 UNGG report that says that the body of international law applies in its entirety to cyberspace. In theory, and no state has come out against this provision, in fact that this report passed, in theory you already have your answer on international law. We already had comment that now the next step is only elaboration. However, this is where you hit the snag that toppled the last UNGG, which is that some states are categorically against further elaboration of how international law applies, because that carries with it the implication of punitive measures that arise from breaking particular sections of law. So how to resolve this impasse? Well, this is one of the reasons why, while everything was frozen at the UN level during 2017 and 2018, discussions were still being held within the hollowed halls of the OSCE about how to start implementing practically sub-legal mechanisms, namely, in our case, because of our mandate, confidence-building measures. These might seem a little soft, especially compared to a law, and you could argue it perhaps even compared to some norms that were also elaborated in UNGG. But some of these CBMs are currently being talked about in earnest on how they can be made to strengthen international cyber stability. For instance, how do states effectively transmit information on vulnerabilities? How can our differences in terminologies, which is a huge problem, because when you say cybersecurity, no two states have the same definition of cybersecurity, or at least few enough not to really count. Bridging these kinds of differences in perceptions and capacities has within it the capacity to start building up a body of customary law that is going to underpin our interactions, or state-to-state interactions in cyberspace, wherever the actual provisions on how to implement international law start to sag and stop.